Hi, my name is Larry Smith with Legacy Transitions, and I put together a group of local professionals to help families dealing with probate. We can help from the little things all the way up to everything. It really depends on your situation and what you need help with. We help with stuff like trash out services, coordinating donations of unwanted property to nonprofit organizations. Other areas include lawn services, locksmiths, estate sales companies, probate attorneys, accountants, title companies, real estate services, moving services. Basically, you name it, our group has it. And you will not believe the amount of stress and load we can take off your shoulders if you just let us. Before we jump in, be sure to like and subscribe to the channel. Turn on the bell notification so that you never miss one of my updates. My contact information is in the description. Now let's jump in. Okay, today's topic, we're going to be talking about contesting a will. Just a quick note, I will tell you that this is not the way you would like to go, so be very careful. If you're thinking about contesting a will, it's expensive and time consuming, not to mention emotionally draining and a real difficult thing for the family. So let's talk about what happens if someone contests a will during probate. When someone contests a will during probate, it means they are challenging the validity or the terms of the will. The specific legal procedures and requirements for contesting a will vary across jurisdictions, but I'm going to provide you with a general overview of what typically happens in such cases. Filing a claim. The person contesting the will, referred to as the contesting party, must file a formal claim or petition with the probate court stating their grounds for contesting the will. Common grounds for contesting a will include lack of testamentary capacity, undue influence, fraud, forgery, or improper execution. Notification of interested parties. The court will typically require the contested party to notify all interested parties, such as the beneficiaries and other potential heirs, about the claim. This allows them an opportunity to respond and present their arguments in support of the will's validity. Gathering evidence, both the contesting party and the proponents of the will, those defending its validity, will gather evidence to support their respective positions. This may involve obtaining witness statements, medical records, financial documents, or any other relevant evidence to substantiate their claims. Court proceedings. The court will schedule hearings or trial dates to hear arguments and review the evidence presented by both sides. During these proceedings, the contesting party and the proponents of the will, along with their legal representatives, will present their cases and cross-examine witnesses. Burden of proof. In most jurisdictions, the burden of proof lies with the contesting party, who must provide sufficient evidence to convince the court that the will is invalid. The exact standard of proof required varies, but it is generally higher than a mere suspicion or speculation. Court decision. After considering all the evidence and arguments presented, the court will make a decision regarding the validity of the will. The court may uphold the will in its entirety, partially, or invalidate it or declare it entirely invalid. If the will is invalidated, the court may enforce a previous valid will or distribute the assets according to the laws of intestacy. That is when someone dies without a will. It is important to note that contesting a will can be a complex, lengthy process. It may involve significant legal fees and emotional strain for all parties involved. Consulting with an experienced estate attorney who specializes in probate litigation is advisable for anyone considering contesting a will or dealing with such situations. I hope that helps you. If you're considering contesting a will, I would not do it without consulting and getting lots of consultation as it is a way to elongate the process and cause more expense. Again, thanks for tuning in. I get calls, texts, and emails every week from many of you looking for help and direction, and I personally love it. So be sure to reach out to me by calling, text, or email, or better yet, even leave me a comment in the comment section. I'll be happy to help you in any way that I can. And again, until next time, take care.